To begin with, focus on health law. This is a presentation of the Law Office of Kenneth Haber. The moderator here is attorney Ramesh Khurana from the Khurana Law Firm of Rockville, Maryland. Their topic in discussion for today is the first part of the two-part series on malpractice and the doctors. Let's join these two famous attorneys now.
I have a great pleasure of welcoming Kenneth Haber Esquire to our studio this morning. Mr. Kenneth, welcome.
Thank you very much, Ramesh, for inviting me here.
Ken is a renowned Maryland attorney, and he is the assistant U.S. attorney. At this point, he has his office in Maryland, in Boyers. Is that correct, Ken?
Yeah,
in Boyers.
Former assistant U.S. attorney.
Yeah, former U.S. assistant U.S. attorney. And today, I'm going to ask him for his advice relating to certain areas which are very important, and I would say that these are considered significantly important by physicians, especially when we are talking about the malpractice issues. No physician would like to hear about any, malpractice claim being filed against him or her. No. Is that correct?
That's correct. That's the last thing they want to hear of.
But still, this is an evil we have to talk about it.
Yes.
Because we would advise all the physicians to take all steps which are necessary to prevent malpractice cases. But if at all, unfortunately, you get involved, like how you want to protect your interest.
Exactly.
So we have our renowned attorney Ken here, who's going to advise physician how to protect yourself against malpractice claims. Now, Ken, what is the beginning of malpractice and the doctor? Like when does this nuisance starts?
Well, the answer is simple. It's the doctor-patient relationship. The doctor-patient relationship is a contractual relationship, and it's out of that and the professional aspects of it that malpractice arises. The professional relationship creates a layer above the contract, but at the same time you have the contractual relationship. So it's in that contract of doctor-patient relationship that you can help protect yourself. A doctor can start off in protecting himself by having contract provisions, and there's nothing that says he can't. He has contract provisions that says he takes assignment of payments. And nothing says that he cannot put in there a binding arbitration clause and a waiver of a jury clause, so that he can select one or the other or have one as a backup for the other. If the courts were ever to strike down the arbitration, which the Supreme Court endorses significantly in clauses, but if it was stricken because of the professional relationship, there's certainly the possibility of having the courts accept the waiver of jury clause. And these are key concepts that will help a doctor protect themselves. Another concept would be a hold harmless for third-party acts, so that the patient, so often when something goes wrong, sues everyone that's involved. And if you have a hold harmless for third-party acts, then if the doctor is vindicated, the patient ends up having to pay for the doctor's attorney, for the doctor's expenses, and all the other damages that can ensue to a doctor. You can have a specific provision providing for the patient to pay attorney fees, costs, and the doctor's time if the physician prevails. So this would give pause to the patient when he's thinking of suing the doctor for on a frivolous basis. He's going to say, wow, I can have to end up paying my doctor. These sort of provisions help select the patients because of the fact, do you want a patient who's going to come to you as a patient who's going to turn around and sue you? If you want that type of patient, well then don't have these type of clauses. If you want to have a self-selecting type of contract that widows out those type of patients who are thinking of wanting to sue their doctor, then you should think in terms of having a doctor-patient contract signed by the patient that has these type of provisions, so that you'd be having, at least at the beginning, patients who are not thinking about suing their doctor.
Now, Ken, as part of your legal practice, do you provide a service for preparation of contract for doctors?
We can, depending upon what the doctor feels comfortable with in his particular. We have done it in terms of his contract with his patients. It's a very personal type of decision on the doctor's part in terms of exactly what provisions you want to have in there. One of the things that doctors have to realize, though, is they can't collude. They cannot collude with other doctors in their medical staff, where everyone in the area is going to have these agreements. They can decide individually that they do want these, but if they collude, somebody can say in some rural area, you know, the doctors all in one hospital are coming up with the same agreement because they all got together and said they're going to agree to it. Well, that gets to the point of possibly being an antitrust violation. You got to be careful about that, but every doctor has a right to decide on his own to implement a doctor-patient contract and have it individualized to what he feels that he wants to have in it. This even goes for current patients. You can always tell a current patient that you're starting to implement these contracts, and that if they want to stay on with you. And once again, it's a very personal thing. How long has this patient been with you? How much do you trust this patient? And you know, what are your feelings with the patient? But certainly it's an option a doctor has.
Can you said in your presentation about two concepts. One is about the payment of attorney's fees, and second thing you said was about the payment of doctor's time. I like these two provisions. Now my question to you is, now in your practice, have you found that if these two provisions are incorporated in the contract, whether these have been found enforceable by the court?
I've never known them to be challenged at this point in time. I haven't used them in any significant number of times. I did in the past a couple of times, and I've never known them to be challenged, so it never came up. I think that maybe that self-selection process might be working there, and the patients who want to sue their doctors go elsewhere.
Right. Ken, just for the sake of clarification, when you talk about the payment of the attorney's fees to the physician, are you limiting to the situation where a physician would prevail in any legal action which is brought against him or her, or irrespective of the fact whether the physician prevails or not?
No, this would obviously have to be where the physician's prevailing. If the physician's not prevailing, then the courts are not going to permit the physician to take attorney fees from the patient who suing them. But if the provisions are there, it'll certainly give pause to a patient not to file a frivolous suit. And so much the doctor has to be concerned about frivolous suits, because if there's even a frivolous suit can result in a settlement, and that goes into the data bank.
That's interesting. Now, are there any warning signals in respect of such a contract?
In terms of
when we are talking about malpractice issue between the patient and the doctor, are there any warning signals when you are looking at the contract?
Not in terms of looking at the contract, but looking at the patients. You know, a doctor can certainly try to determine whether the patient has sued other doctors in the past. You know, by using various records. It's not necessarily a common practice, but you know, if a patient has a reputation of suing doctors, you can certainly exercise your own individual judgment to determine whether you feel comfortable, you know, being a doctor for this patient. I would not advise doctors to jettison patients just because there was a single occurrence, because that patient may very well have had a legitimate basis for a suit and may have been truly aggrieved, and it could be that this is a good patient and you don't want to deprive them of your services.
Now, Ken, of course, in order to protect against malpractice claim, a physician has to buy a malpractice insurance policy. Now, we would like to have the benefit of your presence here in our studios. If you can kindly explain to the doctors, like what does a doctor need to know about the malpractice insurance policy?
Well, one of the things you need to know is your policy limits. How much protection are you buying? And then you need to know whether or not your defense is inside or outside of the policy limits. If it's inside the policy limits, then you're going to chew away at your pot of money that's going to be used to pay off a judgment or a settlement, and you don't want to do that because of the fact that it could leave you exposed. And then you want to know whether or not you have a right if you have a right not to settle, if you have a right to refuse to settle. The insurance policies may give your insurance carrier a right to settle whether you want to or not, and if that happens, you will be reported to the data bank. Outside the policy limits is obviously much more advantageous for the doctor because of the fact that there's more of a fund to pay off a judgment if there is problems.
Ken, in your practice, what's your experience? Because all these physicians are very busy. Do they have time to look at the provisions of the malpractice insurance policy?
Well, they should, or their office manager should, because of the fact that's what's covering them. That's what's protecting them. And so often physicians are so in tune to doing good work in terms of medicine that they forget to cover themselves from a legal and a practical standpoint. They can't forget that if they don't take care of themselves, they're not going to be able to take care of their patients.
Ken, of course, you did mention about the settlement issue. Now we are running out of time for this segment. I would like to ask you one important last question. What will you look into the other consequences of having a settlement or adverse verdict in a malpractice matter? Can you please explain to it, or you want to cover it in the next visit?
Well, we take that up in the next visit, but I just would like to throw out one thought to doctors that the insurance companies truly, in terms of the cost of their premium, they always like to say, oh, it's those darn attorneys that are suing the doctors driving up the cost of insurance. But the real cost of the insurance comes from the lack of proper investment accumulated by the insurance companies, because they got billions of dollars invested in the market. If the market goes up, they make big profits. If the market goes down, they make very little profits or they make losses. So they like to blame the attorneys who are suing the doctors, but that's just a little chunk of the change. So it's really the insurance companies and not the plaintiff's counsel. But
that's interesting to know again.
Yeah.
Yeah.
And I'd like to thank you very much for having me here, and I really appreciate being on the air and opportunity to talk to the doctors.
I thank you very much for coming to our studios. I know that we have seen a signal coming from the cameraman that our time is over. So with this, I would like to thank our audience for being patient with us and hearing views of Mr. Kenneth Haber, a renowned Maryland attorney, and we will bring him again after 2 weeks in the studios, so that we will ask him more questions about the malpractice insurance policy. Thank you very much.